Hi, I'm Catherine. If you're watching this video, then you might be heading to mediation in relation to your parenting matter in the near future. In this video, I'll be explaining the 4 general categories of parenting arrangements. I'll be talking about some topics that you might like to discuss and pop into a parenting plan if we're able to reach points of agreement at mediation. And I'll also be giving you some tips in relation to how best to prepare for mediation, because you'll get more out of the process the more you prepare. We'll start by discussing the 4 general types of parenting arrangements. The first type is an equal time arrangement where the child or children live equally with each parent. Now, this doesn't necessarily mean the child or children have to spend 7 consecutive nights with one parent and then 7 consecutive nights with the other parent. You can be creative with respect to how equal time is established. The second general category is where the children live primarily with one parent, who is referred to as the resident parent, and they spend substantial and significant time with the other parent. So substantial and significant time is usually made up of between 4 and 6 nights a fortnight, in addition to time during school holidays and time on special occasions. The third general category of parenting arrangements is where you have a primary resident and the child or children spend time with the other parent, but it doesn't meet the threshold of substantial and significant time. For example, the child or children might be spending 3 nights a fortnight with the non-resident parent, and there are many reasons why this might be appropriate for particular families. For example, someone's work schedule might prohibit them from spending substantial and significant time with the children, or the distance that a parent lives from the children's school or the children's primary place of residence might impact the time that they're able to spend with the children. The fourth and last category is the most rare to come across, and that is a no-time order, where the children live with one parent and spend absolutely no time with the other parent. Usually these circumstances arise where there are allegations of risk against the person who is not spending time with the children. There are many different types of risk that can impact someone's capacity to parent. For example, alcohol misuse, drug misuse, exposing children to dangerous people who might harm the children, exposing children to family violence, neglect, psychological, physical, sexual, or emotional abuse are other examples. If there is evidence that some risks pose an unacceptable risk of harm to the children and those risks cannot be mitigated some way, then the court might consider a no-time arrangement to be appropriate, pending receipt of evidence that those risks can and have been mitigated. We strongly suggest that both parties obtain independent legal advice prior to attending mediation. Your lawyer will take your instructions and be able to provide you with legal advice based on what type of arrangement they believe is appropriate in your case and the type of orders you might expect a court to make if you proceed to court. That way, you can make legally informed decisions and offers of settlement at mediation. Remember, the mediator's job is not to provide legal advice, and it's not to make decisions for either party. It's to facilitate negotiations. For example, you might think that your matter fits into a particular category, and after speaking with a lawyer, your lawyer might give you advice that actually they don't agree, and this is why. They might provide advice in relation to case law that's applicable, or certain things that are applicable to your case that you might not have thought of because you're not legally trained, or you might not be legally trained. In relation to risks, your lawyer might be able to propose other ways to mitigate risks that you or your ex might not have thought of. Seeking legal advice prior to attending mediation will enable you to make legally informed decisions on the day, and I really can't stress how beneficial that will be to both parties. We're now going to move on to talk about some of the topics or issues that you might consider addressing at mediation and including in a parenting plan. The first topic or issue is parental responsibility. Parental responsibility relates to making major long-term decisions relating to the child or the children. For example, long-term decisions relating to medical treatment, health, schooling, education, and religion. Now, we're not talking about the day-to-day type of decisions. We're talking about major long-term decisions when it comes to parental responsibility. Parental responsibility is something you should definitely speak to your lawyer about prior to coming to mediation, because there are many different options with respect to how you can approach this topic. For example, should this be a case where parents share equally parental responsibility? Is there low parental conflict? Can you make decisions together? Speak to your lawyer about that option. Or is this a case where sole parental responsibility should be placed with one parent entirely? There are other options. So you can also have an arrangement where different aspects of parental responsibility are given solely to each parent. For example, one parent might have sole decision making in relation to medical, and the other parent might have sole decision making in relation to schooling. Another topic that we can discuss at mediation is the time that the child or children will spend with each parent. Again, you should seek legal advice in relation to the worst possible case if you can't reach an agreement and you go to court, and the best possible outcome for you if you can't reach an agreement and you go to court, so you can make legally informed decisions that are child focused at mediation. For example, how old are the children? What was the relationship between the child and each parent like prior to separation? What was the care arrangement prior to separation? What has been the care arrangement since separation? And are the children coping with the current arrangement since separation? These are things that you should think of to prepare for mediation. It's not enough to simply say, this is my proposal. You should really think about why your proposal is in the child or children's best interests. What's important at mediation is the child or children's best interests, not what each parent thinks is fair. So when you're thinking about arrangements, think about how the children might cope with your proposal, and if you truly believe that your proposal is in the child or children's best interests, and why. You should think about changeover of the children. Where will that happen? Will it be at each other's houses on a weekend? Will it be on a weekday? Will changeover happen at school, at daycare, or at some other location? For example, at a McDonald's or another facility that's midway between each of your homes. This is something that you should think about before mediation. If you're going to propose X, well, can you actually facilitate that? Is there any other third parties that need to be involved or talked to before you attend mediation? Do you need help with actually picking the kids up or dropping the school off at the times that you're proposing? Do you need to think about out-of-school care facilities? Do you need to contact the school to investigate those types of things? You should reality test any proposal that you might consider making. Can you think of anything that might prohibit your proposal from working long term? Other topics that we commonly talk about at mediation is communication. How should communication occur between parents? By email, by telephone call, by way of parenting phone application. These are things to consider before coming to mediation. What should be the frequency of contact between the children and the non-resident parent? For example, should there be an agreement in relation to what day and time the children will communicate with the other parent? You should think about this before mediation. Another common topic that's addressed and talked about at mediation is overseas travel. Do the children need a passport? Do we need to talk about passport creation or passport renewal? Who should hold the passport in their safe custody? With respect to overseas travel, from what age should the child or children be permitted to travel internationally with either parent? Should there be a limit on the duration of travel? Should the conditions relating to travel change depending on the child's age? For example, when they get older? Have a think about this before mediation. So I've just given some very general examples of topics that we can discuss at mediation. You should think about any other issues that you consider important to discuss at mediation that is relevant to your particular family and circumstances. You can attend mediation by way of shuttle mediation, where you have no direct contact with your ex-partner at all, or not in shuttle mediation, where you do have direct contact with your ex-partner. If you're interested in learning more about this process, go and watch my video titled Shuttle versus Non-Shuttle Mediation. There are significant benefits to settling and resolving your matter at mediation rather than proceeding to court. For example, it can take years to reach a final hearing in court, whereas at mediation, you can reach a settlement and an agreement on the day without further delay. Mediation usually costs a fraction of the cost of going to court, so you can save your money and spend it on you and your family rather than paying for lawyers. Court is undoubtedly more stressful than mediation because there's usually multiple letters that go backwards and forwards, multiple court events, and then you end with the final hearing where cross-examination of you and witnesses occurs. And so the stress is really ongoing for a lengthy period of time, whereas mediation is one day of mediation and meaningful negotiations. So you rip the Band-Aid off and there's the high stress for one day rather than ongoing over months to years. Also, with mediation, you and your ex are in control of the outcome. If you go to court, a third party like a judge or a registrar will decide your parenting arrangements when they've never met your children and they only get a glimpse of who you are as a person. Also, it can be very difficult to predict the outcome in circumstances where you can't anticipate how the evidence might fall following cross-examination, and you can't predict what might be included in the child court expert and family consultant reports. So if you go to court, there is no guaranteed outcome, and the outcome can be very difficult to predict. Whereas if you go to mediation, you are in control of the outcome. My name's Catherine. I'm a lawyer and I'm a mediator. My contact information will be down below, and take your time to read the description, which is a summary of what we've discussed in this video.